हेलो फ्रेंड्स, यह डिक्टेशन आपको हाई स्पीड शॉर्ट हैंड मैगजीन के लीगल एडिशन से दिया जा रहा है। दोस्तों, डिक्टेशन की स्पीड होगी 80 वर्ड्स पर मिनट। चलिए स्टार्ट करते हैं। 1 2 3 स्टार्ट। Leave granted. This appeal arises out of the judgment dated 7th December 2011 passed by the High Court of Bombay in arbitration appeal (lodging) number 14228 of 2011 in and by which the High Court allowed the appeal filed by the respondent Go Airlines by holding that the arbitrator has the jurisdiction to consider the counterclaim relating to Senvet credit, thereby setting aside the order passed by the arbitrator. Para. Brief facts which led to filing of this appeal are as under. An agreement for aviation fuel supply dated 1st January 2007 was entered into between the parties, under which the appellant Bharat Petroleum Corporation Limited (BPCL) was to supply and sell the aviation fuel to the respondent Go Airlines (India) Limited. Para. Initially, the agreement was entered into for a period from 1st January 2007 to 31st March 2009. By virtue of the second agreement dated 1st April 2009, another aviation fuel supply agreement was entered into between the appellant and the respondent for the period from 1st April 2009 to 31st March 2011. On 6th July 2009, the appellant issued letter to the respondent along with the statement giving details of invoices and requesting inter alia that the payment of outstanding dues as well as the interest amount of rupees 1.45 crores be released immediately. In reply to the said letter, the respondent by its email dated 6th July 2009 stated inter alia that the outstanding interest was rupees 1.41 crores and not rupees 1.45 crores as mentioned in the said letter dated 6th July 2009. As the payments were not made, the appellant BPCL put the respondent airlines on cash and carry terms on account of default in making payment for supply of fuel and interest on delayed payment. Para. Dispute arose between the parties when the appellant raised a claim for interest for the delayed payments of the fuel supplied during the period from 1st April 2009 to 31st March 2011. The respondent did not accept any amount payable towards interest. Since the dispute in respect of the liability and payment of interest on delayed payment could not be resolved through mutual correspondence between the parties, the appellant vide its notice dated 25th March 2010 invoked arbitration clause, that is clause 12 of the agreement dated 1st January 2007, suggesting the name of Mr. Justice (retired) Sujatha Manohar as the sole arbitrator. The respondent vide its letter dated 27th April 2010 agreed to the dispute being referred for arbitration and accepted Mrs. Justice (retired) Sujata Manohar as the arbitrator. In the said letter, respondent stated that they are sure that the learned arbitrator would be able to adjudicate the issues appropriately, considering the respondent's various claims against appellant BPCL. The appellant raised a claim for an aggregate sum of rupees 1,95,21,032 rupees with interest at the rate of 18% per annum from the date of presentation of the said claim till payment and or realization. Stop. दोस्तों, डिस्क्रिप्शन बॉक्स में दी गई डिटेल्स के अनुसार आप हाई स्पीड शॉर्टहैंड मैगज़ीन का लीगल एडिशन और रेगुलर एडिशन खरीद सकते हैं।